Please subscribe, press the like button, comment, scream, send it to your favorite uncle, but please do something with it. I'm a 35-year practicing lawyer. This is not legal advice, but this is more about how I would analyze the possible issues that were involved with regard to Dan O'Dowd. In my last video, in anticipation of Mr. O'Dowd of Green Hill Solutions, who's a so-called competitor of Full Self-Driving, and his commercial that would be ripping Full Self-Driving during the Super Bowl, I indicated I would address the legal issues that related to it as I saw it. Apparently, instead of the commercial being aired nationally, it was only aired in Washington, D.C. and other state capitals throughout the United States, including Sacramento, California. So this reflects an ongoing dispute involving O'Dowd and Tsla. O'Dowd lives in Santa Barbara, California, and he is also a billionaire. And he has a dispute because he competes with Tsla with regard to full self-driving. They have another system that they assert would do the same functionality. I'm not even addressing in my analysis whether what is stated in the video is what occurs in the video, because there's a dispute as to that. But I'm just going to take the video as it is stated and kind of tell you how I perceive what's going on. So, for the actions of O'Dowd in the past, he objected to FSD and asserted issues related to safety. And in effect, it appears that he was trying to tie up FSD. And what he did assert is, in a commercial, he asserted that there were safety issues with regard to FSD. And he also made the same issue during the Senate campaign, in which he was running for Senate in California. It had to be a very small issue, however, because he only received 1.1% of the vote. I believe he finished 9th in the senatorial primary, and he used a lot of his own money, which is good to know. But because of apparent false statements that he made in his original commercial, asserting that, I believe, something on the order that children would die as a result of FSD, or statements to that effect, on or about August 11th of 2022, an in-house counsel of Tsla sent a cease and desist letter to O'Dowd, and I think the attorney's name was Dina Eskin, and she was associate general counsel at the time. Anyway, a cease and desist letter was sent to O'Dowd and to the Dawn Project, which was the name of O'Dowd's project, directing them to stop, remove the videos, issue a retraction, disclose all funding sources, and disclose all regulatory agencies that were supporting their analysis that they had performed. There was also an evidentiary preservation request, which means basically don't destroy any evidence. I don't know if any of the conditions that were part of the cease and desist letter have been complied with. I'm guessing none, maybe except reducing the number of publications. But up until the date of the Super Bowl, things had quieted down to some degree. So the claim was the video and the comments were defaming of Tesla's reputation. And that was what was contained within the cease and desist letter in August of 2022. And we get to the Super Bowl ad, and I've reviewed the ad. I've looked at it a few times. And just to give you a little background, there are basically two types of defamation claims, and that was the claim that was referenced in the cease and desist letter. There's libel and slander. So libel is generally written or electronic writing, and slander is spoken. So you can have both. In this case, in the video, you certainly have spoken because there's words, but there also may be written, especially if there's closed captioning or something on the order. So it has to be, of course, a false statement. And this also has to be looked to in the background that you have a First Amendment right to speak. So that right is very well protected. So defamation is very closely scrutinized in order that people's First Amendment rights are not trampled upon. And along those lines is opinion is not actionable defamation. So if I assert something that, in my opinion, this was the case, then that in itself is not an actionable statement. And people try to often craft their statements to make them appear like their opinion. But ultimately it would be up to a court to decide, or a court or a jury to decide, whether it was an actionable opinion or a statement of fact. Because if it's a statement of fact, it can be actionable. For defamation, again, libel or slander, if what the person is saying is true, that is an absolute defense. So if I call somebody a scumbag and they're a scumbag, that would be an absolute defense to the claim of defamation. So it has to be a false statement. For example, that FSD kills kids, not opinion, and it has to be published. So it has to either be broadcast, spoken about, or written about. And each time it's broadcast or published, as it's called, that's a new claim. So if I accuse Bob of being a thief and I tell two different people on two different occasions, that is two separate claims. Now in this particular commercial, I don't know if it was aired at the same time in all the jurisdictions, but it appears to have limited airing, and that may be an intent to provide some downside risk against exposure. So maybe O'Dowd thought, if I only publish it once, my risk is limited, and if I publish it 50 times or twice or 3 times, whatever, those are all separate claims, and I may have bigger exposure. So you also need to prove damages in a defamation claim. So it's not just the fact that you damage somebody's reputation by calling them something that doesn't apply. It also has to, in effect, damage their reputation. And you can present that by expert testimony, or there may be numerical ways of proving it. Business might drop off after the comments, and you might be able to show the difference. But there's ways of establishing damages. And there are certain accusations that in and of themselves, like accusing someone of a crime, where damages are presumed, and you don't have to prove that up. So in this case, in the case that we're looking at, there are two particular statements that caught my attention. And I believe they're both not statements of opinion, but statements of fact. And I think they're problematic. One was, it will hit a baby in a stroller. So to me, that's not a statement of opinion. That's a statement of fact. And on the video, it's also deceptive because it shows a car careening into a stroller, but there's no baby in the stroller. So they're using a false image to create the impression that a baby's been hit. And the same with, they also said it will run down a child in a crosswalk. And the same thing. They show an apparent dummy or something in a crosswalk, and they run over it, and they, again, in a deceptive way, they're trying to show that a child has been hit. I don't believe that's opinion. I believe, in my opinion, that's actionable misconduct. That's a statement that's not true and is deceptive. And if, in fact, beyond that, there are occasions or evidence that show that what they assert in the video is not what is shown, and they knew that, that also might establish malice. And if you can establish malice, that might let you obtain punitive damages against the person for intentional misconduct. And along those lines, if it's a public figure and somebody's accused of defamation, if it's a public figure, in order to recover, if you're a public figure, you have to show that there was in fact malice. If it's not a public figure, you don't have to establish malice. So that takes us up. So could Tesla sue for defamation? I think they could sue for defamation. The questions that would exist is, has Tesla been harmed by this? Has her reputation been damaged? I don't know if O'Dowd has any credibility, and if in fact that the reputation has been damaged. But the bigger issue is Tesla might be concerned that by having a trial, a public trial, that they might have to disclose confidential features of FSD. And even if there's a sealed court and a sealed court order, they may be concerned that ultimately the features may get out, and they don't want to disclose those features, and that may be enough in of itself to prevent them from pursuing relief in court. On top of that, they may not know if there's a favorable judge or jury, and they may not want to take the risk. On the flip side, and this is kind of how I see it, on the flip side, and I had mentioned this, I believe, when the original dispute came out at the time of the cease and desist letter, how about being able to show in a public courtroom the functionality of FSD? Have the judge drive from O'Dowd's house to the courthouse without any engagement. Absent the issue of the confidential information, a trial involving full self-driving would seem to provide Tesla a golden opportunity to demonstrate its value to the world. So I'm not obviously affiliated with Tesla, but that's something that occurs to me, that it might be an opportunity for them to show it off, have a public, basically, pronouncement, and put O'Dowd in his place. Now, notwithstanding the defamation claim, even though there is in the cease and desist letter it only referenced defamation, there are other claims that might apply that Tesla could pursue against O'Dowd and the project. For example, there's claims called, and they're basically economic interference. And they can either be negligent or intentional. So I could either intend to disrupt your business, or I should have known that I was going to disrupt your business, and therefore I was negligent. So one requires specific intent, and one can be done negligently. The same argument that he was sending out false videos about Tesla and the FSD, and it was intended to harm the business of Tesla. And again, you'd have to establish damages. You might be entitled to punitive damages if you could show intent or malice. So those are the claims that pop into my head. There may be plenty of others. It seems to me it's an opportunity, if it applies, and if it doesn't disclose confidential information, where Tesla can really establish the propriety and the functionality of FSD in a public courtroom, to the detriment of Mr. O'Dowd.